The Chief Controlling Revenue Authority and another versus Reliance Industries and another, decided by the Bombay High Court in the year 2016. In the year 2002, the Board of Directors of Reliance Industries Limited and that of Reliance Petroleum Limited accorded their consent to the scheme of amalgamation of Reliance Petroleum Limited into Reliance Industries Limited. Both RAL and RPL filed company petitions before the Bombay High Court and Gujarat High Court respectively for the sanction of scheme of amalgamation. Accordingly, the Bombay High Court passed its order on 7 June 2002, while the Gujarat High Court passed its order sanctioning the scheme on 13 September 2002. Since the scheme involved transfer of property from RPL to RAL, it attracted stamp duty on the property. Accordingly, the Collector and Additional Superintendent of Stamps, Gujarat, demanded for stamp duty of Rs 10 crore, which was duly paid on 18 September 2002, whereas the stamp duty applicable in Maharashtra was Rs 25 crore. Requesting for rebate of the stamp duty paid in Gujarat, Reliance Industries Limited addressed a letter to the Superintendent of Stamps, Mumbai, seeking reduction in the stamp duty to the tune of Rs 10 crore paid in Gujarat. Since Reliance Industries Limited paid only Rs 15 crore and for the sake of the balance 10 crore, the DSS issued a notice and called for a hearing for Reliance Industries Limited. After the hearing, the DSS Mumbai passed an order dated 7th April 2003 rejecting the plea of Reliance Industries Limited and demanding the payment of the entire stamp duty. Aggrieved by the same, the RAL filed an appeal before the Chief Controlling Revenue Authority. The Chief Controlling Revenue Authority dismissed the appeal vide its order dated 10th August 2005. Aggrieved by such dismissal, RAL filed a writ petition whereby the matter was referred back to CCRA by the Bombay High Court vide its order dated 22nd February 2006. The CCRA again rejected the plea of Reliance Industries Limited, which led to the current writ petition, wherein a civil reference was ordered under the Bombay Stamps Act 1958. The four issues framed by the Bombay High Court in the current writ petition are: issue number 1, whether the scheme is chargeable to stamp duty if the order is passed by two different high courts. Issue number 2, whether the instrument in respect of such amalgamation is the scheme and the orders sanctioning the schemes are only incidental thereof. Issue number 3, whether the transferee company is entitled for rebate in respect of the stamp duty already paid in the state of Gujarat. And finally, issue number 4, whether such scheme be construed as a document executed outside the state for the sake of rebate under Section 19. The Bombay High Court simplified the case by framing one single question to decide as to whether the scheme is the instrument or the order of the court is the instrument which decides the entire suit in the particular case. In order to decide that, Reliance was made on this case Hindustan Lever vs State of Maharashtra, wherein it was clearly held that the order of the court sanctioning a scheme is the instrument which affects the transfer of the property, and hence it falls within the definition of Section 2L of the Bombay Stamps Act. In order to decide whether rebate is applicable, Section 19 has to be looked into, wherein Section 19 says in order to claim for a rebate, the such instrument has to be executed outside the state. Number 2, the property has to be belonging in the state. And number 3, the instrument has to be subsequently received in the state of Maharashtra, and hence there is no rebate which is applicable in this case. And the stamp duty is charged on the instrument and not on the transaction effected by such instrument is what was held by the Bombay High Court. And finally, the High Court held that it is the order alone which is an instrument and not the scheme. By this, the Bombay High Court decided the case in the favor of the revenue and demanded Reliance Industries Limited to pay the entire stamp duty.